Hello, everybody. It is noon, so we are going to go ahead and get started. I don't want to keep you here too long today. Uh, my name is Jordan Walker. I am an attorney with the law firm Seaver Story Walker. Today, we're going to be talking about eminent domain, the state of Georgia, what to do if your property is affected by a road project, by an eminent domain acquisition. We are going to talk about our experience. We have quite a bit in this field doing this particular type of law. So today we're going to be relaying that experience and kind of walking you through what happens, what comes next, what to expect over the next several months, possibly a year during your acquisition. So with that being said, I'm going to go ahead and share my screen so you guys can see my presentation. Okay. So again, what are we? Who are we doing? Who are we rather? What are we doing today? Again, I work for the law firm Seaver Story Walker. My name is Jordan Walker. I am the Walker in that name. We are eminent domain attorneys. We are eminent domain attorneys only. This is the only area of law we practice. And further, we only represent landowners at our law firm. We have never worked for a condemnor. We've not worked for GDOT. We've never worked for any of the counties, municipalities in Georgia. We are landowner only. As a consequence of that, we've learned quite a bit, which I said earlier, but our experience allows us, to deal with pretty much any experience a landowner is going to have to go through. We pride ourselves on our knowledge of the law and helping out landowners in the state of Georgia. And with that being said, one question I get a lot off jump is, why am I getting this letter? This is the first I've heard of this project. This is the first contact I've received on this project. Why did I get it? The reason why you received a letter from our firm was because we monitor, we keep tabs on all of the projects in the state of Georgia, where they are in the various stages of the projects, and on the project that is affecting your property. What we found is that they've at least begun acquiring some of the land on that project. So in other words, the reason why you got this letter is because somebody else, at least one other person, probably several other individuals, have not only received an offer, but they've actually finished their case and conveyed the property to the municipality or GDOT. So what that tells me is that your project is in the midst of land acquisition. Now, I'll caution that land acquisition sometimes takes quite a bit on any project. These projects usually require a lot of land to be acquired. So just because your neighbor or somebody down the road has maybe gotten their offer and gone through the whole thing with GDOT already, and you haven't received anything, that doesn't necessarily mean anything. It doesn't mean you're doing anything wrong. That doesn't mean that you need to contact somebody or reach out, or have you been forgotten or something like that. That's not how it works. These projects obviously involve a lot of moving parts, a lot of land to be acquired, and GDOT and whoever is acquiring the land has a schedule, and it's a schedule that we can't know. And it might not make sense from the outside looking at it. Why have they already acquired my neighbor's property? Why have they not contacted me? And that's just because that's how they're doing it. It isn't necessarily, on these projects that they just go right down the line and acquire every single one all in a row. Different parcels are assigned to different appraisers, which are assigned to different right-of-way agents. And so it's not uncommon for folks to, not have any idea what's going on while other neighbors have already gone through the process. So don't be concerned if you haven't received anything from GDOT. What I caution folks is that when they want your land, you will know that. They are going to make their presence felt. They are going to contact you. They're going to reach out to you. They're going to email you. They're going to call you. They're going to stop by your house. These are this is required of them to reach out to you under the law. So don't be concerned if you got this letter and you have no idea what's going on. All you need to know is that according to our research, your property is in the line of a project. And they have at least acquired some land on that project. So we anticipate at sometime in the future, they're going to come through and contact you for your land as well. So now that I've said that, real quick, again, what we do, this is it. This is all we do. We are not with the condemner. I do not work for GDOT. I never have. GDOT is in an adversarial position to our firm generally. So I just like to stress that up front because some folks get confused and think we work for them. We do not. And again, what we're going to be doing today is talking about eminent domain and key points, what to look for in the entirety of the process. So real quick, what is eminent domain? A lot of people don't know what it is. I fairly often have to explain it to people when they ask me what I do. Eminent domain essentially is the forced acquisition of your land for a public purpose or a public use. The most common type exercise of eminent domain is by the state DOT for a road project, whatever that project may be. It is the most frequent use of eminent domain, and it's the one that all the landowners in this webinar are affected by road projects as well. So the long and short of it is that eminent domain means you can't reject the offer. You can't say, I'm not going to sell it to GDOT. I'm going to keep my land forever and there's nothing you can do about it. You can't do that in an eminent domain acquisition. Ultimately, if the project happens and the DOT wants the property, if they follow the law, they can take it. So that's kind of a very rudimentary understanding of what eminent domain is, but it's effectively the forced acquisition of your property. Meaning they can take it, but they can't just take it and give you nothing for it. You are entitled under the United States Constitution, the Georgia Constitution, to just compensation. It's not just compensation, it's just compensation. We say that sometimes. Basically what it means is you're entitled to justice. And the GDOT's opinion of what you're entitled to from a compensation perspective is not the end-all be-all. They do not control what your land's worth. They are not the only entity that has an opinion of value of your property that can be considered in a courtroom. So ultimately, and you have your voice, you have your right to what's referred to as just compensation. You can you have a say ultimately, or you have at least an ability to put forth evidence on what your property's worth. And the reason why I say all this is that sometimes folks think that if you go to eminent domain, you get nothing, or you get less, or you get some de minimis amount. That's not how it works. All it means is that rather than it being a private transfer between the parties, ultimately it could end up in the hands of a jury what your property is worth, what your compensation amount is worth. So just be, and I'm saying this not because your property is going to go through the eminent domain process. We'll talk about that in a bit, but only to be, I'd be wary and cautious of what right-of-way agents tell you during these negotiations, during these discussions, because they will say things that are not necessarily true. And one of those things we hear a lot is that if you go to eminent domain, you'll get nothing. It's not how it works. And so back to eminent domain generally, the condemner, in this case, it's GDOT, it's the county. They have the inherent eminent domain authority, meaning they have it just as a matter of course. They still have to get the court approval of the exercise of that eminent domain. However, if they follow the law and they follow all the requirements prior to filing an eminent domain lawsuit, they will be able to take the property. So I tell people it is not easy to challenge the taking. We have certainly done it before. I'm currently doing it at the appeals court level in the state of Georgia, challenging a Georgia landowner's acquisition. But ultimately, even if you are successful in a challenge, all that means is that they go back to the drawing board, they start the process over, they follow the law, and then they get the land eventually. So challenging road taking acquisitions are very difficult. If that's something you're interested in, we can certainly talk about it, but it is a uphill climb. I'll say that. So here's with that being said, here's the eminent domain acquisition process, and this is, as defined by me. These are really the key points of an eminent domain acquisition. The first step, and this is the step that I tell people, this is how you know you're about to get an offer, is when the GDOT appraiser comes out and appraises your property. So the first step is the appraisal, and you'll know that, and you should know rather, that the appraisal is being done by the Georgia DOT or the county appraiser, because they will send you a letter that says, hey, we're coming out on this day. You have the option to be present during this appraisal if you want to be. We are going to appraise the property. When you get that letter, and they will send the letter. They should send it certified that says, hey, we're coming out and appraising the property. That's when your ears should perk up. Not because you necessarily need to be a part of the appraisal process. I don't think it's necessary that you be there or not. But what that means is once you get that letter, that means the offer is coming probably within a month, maybe 2 months after the appraisal is done. That's not a hard and fast rule. That is a generalized estimate. But I tell folks is that once they come out and do the appraisal, you're probably looking at a couple months, maybe less, before the offer ultimately is issued by the DOT that is premised on that appraisal that was performed. So they come out, they do the appraisal, or rather they send you a letter and say they're going to do the appraisal. They come out, they do the appraisal, that appraiser disappears. You never see them again. What happens next? A new person comes in, working probably for another company, possibly the same company, comes in, and then they are your right-of-way agent. And the right-of-way agent's job is to get your land with that appraisal, or at least information from that appraisal, with an offer. So they do the appraisal, then the right-of-way agent issues the offer. And I tell folks that's when our firm generally gets involved, because then you have a case. Up until the offer is issued, you're kind of guessing what the acquisition looks like, how much do they need, what are they going to offer. All these things are kind of in flux until the offer is actually issued to the landowner. And when they issue the offer, they'll give you a packet of information. They'll provide a summary statement on just compensation. That is what I call the offer in earnest, and that is basically a summary of what they are offering you. And they will issue that offer to you. That's when our firm gets involved. So they've done the appraisal, they've issued the offer. A lot of times, I should say, when we get involved, a lot of our cases resolve at the second stage of the process, the pre-condemnation negotiations with the DOT, with the county. That's where most of our cases resolve, but not all of them. Some of them they can't be resolved pre-suit because the DOT or the county won't come up with the necessary money to properly compensate you for the acquisition. And in those scenarios, usually where there's a big difference of opinion, in that scenario, it's actually in your interest for the case to go to eminent domain, because that will be the only venue where you even have a chance at getting what you're compensated for. So again, most of our cases, I would say most of cases generally resolve prior to the litigation portion of the process, the lawsuit, the eminent domain portion of it. They resolve in the second stage where the offer is being made, negotiations are being made. Again, not all the time, but I would say most of them resolve there. And again, it's not necessarily dependent on you that the case resolve at the second stage. That's really going to be dependent on how GDOT responds and what GDOT is willing to give you. Are they willing to get to a point that properly compensates you for your property? If they don't, and it's a significant amount of money, then eminent domain is probably the right choice in that scenario, assuming you're represented and you do have a plan. So the third stage is the eminent domain process, or the eminent domain litigation stage of the process. That's what is formally or generally referred to as eminent domain. It's also referred to as condemnation. And once you reach eminent domain, what that means is that the DOT or the county will, negotiations have broken down. It's obviously the deal won't be reached. GDOT or the county needs the property. They can't sit on their hands and thumbs and wait for a deal to be reached. So they'll just file their lawsuit. And what that means is they will file a lawsuit against you, the property owner, in the county where the property is located. You will be served a copy of this paperwork. But I want to stress that once you get served that paperwork, if you ever get served an eminent domain a lawsuit, and this applies to this, or if you have a lot of property and it happens again, or what have you, if you ever get served a condemnation lawsuit, you absolutely need to contact an eminent domain attorney immediately, because you have 30 days to respond to that lawsuit. And you have to respond basically saying that you disagree with what the DOT thinks your property is worth in this offer that I referred to earlier. If you don't file the necessary paperwork objecting to that amount of money that was filed, that was determined by the DOT to be your compensation, if you do not file an objection within 30 days of that lawsuit, your case is over And all you get is exactly what the DOT originally assessed your property at. So just keep that in mind. I don't think we're at that stage of the process with most of the folks on it that we mailed to. I don't think anyone here has received an eminent domain petition yet. But if you do, time is of the essence. You can your case can be over before you know it if you don't respond to that lawsuit appropriately. So back to negotiations, because as I said earlier, this is where most of the cases get resolved through our firm, I should state. And this is kind of what to do and what not to do when you get that offer from the right-of-way agent. And these are tips that we advise everybody generally to do when they get this offer. What to do: insist that the right-of-way agent communicates with you basically only via email. Text is fine too. The reason why I say this is you want everything on the record. You don't want in-person conversations with right-of-way agents, because what will happen is they will write everything down later, and then they'll tell everybody what you told them. And then that becomes part of your file. As the case moves throughout the process, they will write that down, and they will, we don't know how they're going to write down what they think you said or what they thought you said. And ultimately, it's not helpful to have any of these conversations via verbal conversations, because the right-of-way agents will say all sorts of things verbally that they would never put via email. And when they tell you things verbally, it doesn't mean much of anything. Make them put all communications in writing. I tell folks that email is the easiest way to do it. They are probably not going to want, sometimes they do, sometimes they don't. A lot of right-of-way agents don't like email conversations because it creates a record, and it creates a tale effectively of what happened with the landowner and the lower during the negotiation process. It is not to your benefit to have any communications what is effectively off the record. And if it's not via email, or if there isn't a writing involved, which it's either text or email, then you are not doing yourself a service negotiating like that, because they'll say all sorts of things, and you don't. But then they'll say, "Well, I never said that," later. And so what I tell folks, and they say this that because they can verbally, but when it gets down to email, they start to choose their words a little more carefully. And it is just in your benefit to get all these communications on the record. Strongly advised to, and they will, when they reach out, sometimes they will say, well, we don't do that. We don't send via email. And what I tell people is say, okay, well, we insist that you send it via email. And, if it becomes a problem and they absolutely refuse to, then you can just contact me and we can square it out with them, because they generally listen to what I ask them to do. Okay, once the offer is out there, they want to give it to you, again, do everything via email. And if they don't do email, have them send it in hard copy. I guarantee you they can email it. They probably just don't want to. So I would insist on it if you could. And then what I tell people is that once you get the offer, respond, and all I tell people to say is thank you for this. We've received it. We will review it, and we will get back to you in a week. That way, you give yourself some cushion. They know that you got it, so they accomplished that goal, and they don't need to confirm that any further. You're doing your due diligence, and you're giving yourself a little bit of a cushion before they start bugging you again. They should, hopefully respect your wishes, and you're also not informing them that you're just going to sit on this forever. A week is a very reasonable time to evaluate something like this. So it gives you a little time to decide what you want to do. That's what I tell folks to tell them. Thank you. We'll review it. We'll get back in touch with you. And then the next step, once you get that offer, contact an attorney for them to review the offer. Now, our firm, I do these offer reviews for free. I do them constantly, pretty much every day. I'm evaluating a new offer that's being issued. So if you reach out to me and say, Jordan, I don't know about this offer, I'm not sure what to do with it, just send it to me. Send me the summary statement, send me the map. I will respond, and I will give you my assessment, and you can decide what you want to do at that point. At the very least, you have some input on how this process or how your case should move through someone who has experience with this type of acquisition, this type of process. Again, it's not a big deal for me. If you want to text the offer to me, that's fine too. If you want to email it, that's obviously easiest, allows me to assess it. And I will get back to you probably within the day or 24 hours. So this is a quick review. I don't need a lot to judge these and assess their, what they say. So just send it to me. I'll give you my thoughts. And if you don't contact me, contact an attorney, another eminent domain attorney. If you have another one in mind, at the very least, get a second look at this because it's imperative that you get a second set of eyes to take a look at this, because a lot of times you don't even know what you're looking for. And then finally, I would avoid in-person discussions, negotiations. Right-of-way agents absolutely love to get you one-on-one, in person, having these verbal discussions, throwing out numbers. They love this. They love this. If you're engaging in this, you're already doing the wrong thing. This is not how the deal needs to be negotiated. You're probably going to get taken advantage of. This is not. They will, again, make all sorts of promises and statements that mean nothing. A verbal promise is worth the paper it's written on. And especially with the property transfer, where everything needs to be done via writing. I would, again, avoid in-person discussions, avoid in-person negotiations. They will absolutely try to do it. And that's where they start to seize on all of their skills they've learned over the course of years, trying to get people's land. So I generally say avoid those discussions, in-person negotiations and discussions. So that's what to do, what not to do. And this we'll speed through these because I already kind of touched on a lot of them. Do not engage in negotiations or discuss value before you talk to an attorney. This is what they want you to do. They want you to start throwing numbers out, because when you start throwing numbers out, they start writing them down, and then they know what you are entitled to, or they know what you want out of it ultimately. And the reality is, with a lot of these cases, that what you're entitled to, you might not be aware of the extent to which their offer is deficient, because you think, okay, they appraised the property, that they had to do their job, right? How bad could it be? The reality is it can be very bad, and we'll get into some examples here in a bit. But you don't know what you don't know, and so a lot of people think, okay, well, I've sold some property before. I think I know how to do this, and I'll just throw out some numbers, see what I can get. That's a good way to get a bad deal, by not including or acknowledging all of the impacts and what you're entitled to under Georgia law. That you can't be expected to know. You're not a Georgia eminent domain attorney. Do not enlist an appraiser. This is a big one, because a lot of times the right-of-way agent will tell you, well, we have an appraisal, so you go out and get yours, and then we'll go from there. The reality is that you don't need to get an appraisal. And appraisals in these scenarios, I should say, you don't need to get an appraisal if you're not in litigation. And these appraisals are not cheap. A standard eminent domain appraisal is going to be probably, if it's a partial taking, you're looking at $3,000, $4,000, $5,000, $6,000, and that's even for residential. These are not cheap appraisals, and for you to go out and get one, you think, okay, well, now I have this appraisal. GDOT will certainly listen to it. They don't need to do anything. They can say, well, we disagree. We have our own appraisal, and it says this. We disagree with your appraisal. And then you're out that money for what? You didn't really accomplish a lot. And again, and that's assuming you actually got an appraiser who properly appraised the property, considered all the aspects and impacts and effects under Georgia law that need to be considered. So again, it's not necessary to get these appraisals. Usually it's entirely unnecessary. A lot of times in our situations, we've negotiated on behalf of landowners before. We've gotten significant increases without having to spend money on these appraisals that, again, are not cheap. So, and I'm not in the interest of spending my clients' money unless it's absolutely necessary. In our view, my view with my clients is that we're not going to get an appraisal. We're not going to spend that type of money unless it's absolutely necessary. And it's only absolutely necessary when you're in eminent domain, when you're in litigation. One of your case might be one of those where it is necessary. Most of them are not. But just, I don't want you to make an unnecessary outlay, spend money on something you don't need to, if you don't have to. Again, don't meet in person with the right-of-way agents. I've touched on that. Don't make a rush decision. They like rush decision. They like quick snap answers, because a quick answer is probably a bad one. But at the same time, I have a lot of folks that get these offers and they ignore it. That is also a poor choice of, a poor path to take. Do not just take the offer and throw it away or put it aside and never think about it again, because that's a good way to end up in eminent domain when you probably shouldn't be there. So just, it's not something, again, where you need to make a quick snap decision, but you also don't want to just put it on a pile of papers and forget about it. And that happens more often than I'd like. So let's talk about compensation specifically when you get this offer, what you should look for. I refer to it as keys to your case. The first thing that you need to consider in this acquisition is, what's the value of the land? What's the value of the property that they're acquiring? The taking. The taking is the acquisition. The acquisition. And that's determined, of course, by price per acre, price per square foot, by examining comparable properties in the area. It's not unlike selling your house. However, it is unlike selling your house in an eminent domain context when you're examining the value of your property as it may be on the open market and not necessarily being sold for the use it's being put to. So an example would be, let's say your property is residential, it's being used residentially, but it is surrounded by commercial land and commercial development is headed your way. In that scenario, even though your property is being used residentially, you could have an argument that your property should be valued commercially. And that's referred to as the highest and best use analysis. It's fairly common for GDOT and condemners to come in, look at your property, see that it's a house and say, okay, that's a residence. We're only going to offer residential values, and ignore the surrounding area, what the ultimate values might show. So that's something to keep in mind. There are three approaches to valuing property: sales, income, and cost approach. That's appraisal terminology. But depending on what approach you do, it could render higher values. Ultimately, in this case, for determining land value and determining really a lot of portions of your argument at court, I should say, experts are going to be important. Appraisers, I mentioned that earlier, which again, we only get if it's at court, if it's at litigation. You need to prove your case. You need to hire somebody who's an independent appraiser that supports your position. Then at that point down the road, that's when experts really come into play, and you need to make sure that money you spend on that appraisal is absolutely worth it. And then on top of this, the acquisition, you could also be entitled to business losses if your property is generating income. So if you have a lease, if you're a landlord, you have a tenant, and this affects your lease income, that's absolutely something that you could be compensated for. If you have any other type of business, any business that's generating money on the property, you could also be entitled to business losses. That is something that GDOT will never offer. They won't even acknowledge that it is compensable. So keep that in mind. It's something that it's almost that which shall not be named when dealing with GDOT municipalities, but it is absolutely compensable under the law. And then the second key to your taking, and this is for partial takings only. So partial taking is when, of course, they're only acquiring a portion of your land and leaving a remnant. In a partial taking, you need to keep your eye out for remainder damage, and that is a term that basically covers all of the damages that that the acquisition may cause to the remainder or the remnant, and that can be caused by a number of different things. It could be you could lose access to the parcel. You could have a different shape. Your house could be a lot closer to the road. That's a fairly big one on residential partial takings. Lessened proximity to the road, lessened setback to the road often results in a decrease in the value of the structure itself, and that's something that requires compensation. If your highest best use is changed because of the acquisition, maybe it's too small to develop, or the access loss renders it non-commercial. If it results in ordinance non-compliance, if all of a sudden your property is non-compliant with local ordinances and you are now in a legally non-conforming property, that has an impact on value. The remainder damage, consequential damage, they all mean the same thing. They come in any number of different ways or impacts that exist from these acquisitions. I see them, I can identify them relatively quickly, but it's something to keep in mind when you are looking at this offer if you have a partial taking. And then finally, this is the final key to your case. This is relocation, and this is only if it's a total taking, only if they are displacing your house or your business. And they are the minority of the type of acquisitions that exist on road projects, but they absolutely exist. If you have a property that's going to be displaced, either residential or commercial, you have a whole new bucket of compensation that comes into play, and that's referred to as relocation expenses. This is separate and apart from the property or the compensation you get for your property itself. For residential relocations, you get moving expenses, and you also get a differential payment, which can be significant. And so, for example, if they're taking the entirety of your house, it's worth $400,000, but to get you into a new property that's on the market, the houses, similar houses are selling for, let's say, $500,000 or $600,000. Then not only do you get the 400 for that's your property, but you can also get another. In this case, if it were $600,000 getting a new home, another $200,000 in non-taxable differential payment. That's what it's referred to as. And I put it right there. Differential. It is significant. It is non-taxable. The attorney can also help limit the taxable impact in general. I can in these acquisitions. Commercial is the same thing, but you do not get the differential payment. And I'll just say that just like the offer, if you are being relocated, please be advised that trade fixture reports for commercial relocations or for residential relocations, the relocation estimates are usually not enough. Differential payments usually aren't fairly adjudged either. So again, long story short, anything they give you, be skeptical of the document they're providing. Get a second opinion. Because what you're getting might not be what you're entitled to. Okay, folks, we're almost to the end, and then I will open up for questions. How can I afford an attorney? I can't speak for other counsel, other attorneys. The way our firm operates is a contingency fee. You don't pay me for me to be your attorney, at least not up front. There's no retainer fee. You don't send me money or anything. There's no money exchange at all until the case is resolved. An easy example is if you had a $10,000 offer, you hire our firm and we get you $100,000. Our firm takes a third of the difference that we add to the case. Pretty simple, pretty straightforward. The money comes out at the end. You don't need to send me money for me to be your attorney. It's as simple as signing a contract, and we take it from there. And then once we get the right amount of compensation, the money is distributed. We take our portion. The rest goes to you. Pretty simple, pretty straightforward, and we like it this way because then we become partners with the client, and we have some skin in the game, so you can trust that obviously we have your best interest because we have our best interests at that point. And at the end of the day, we talk a lot, of course, about knowing the law and educating landowners, but we also understand that ultimately our results are going to define us, and we are a results-based firm, meaning I define my success by not how well I know the law, but how much more money I can get for landowners affected by this. These are some examples of where landowners have started, where they've ended. I want to clarify that these are not guarantees of success. I'm not guaranteeing that if you have a $15,000 offer, you're going to get $3 million. I'm not guaranteeing that at all. What I am saying is that these are examples of how offers can be so bad, be terrible, and what can be left on the table by accepting the first offer or trying to work out a deal with the right-of-way agent and missing, potentially millions on the table. And I'm not saying you have millions that you're leaving on the table, but you never know. And there are, that's my job, is to look at your offer and see what type of money exists on the case out there that you're not being compensated for. And these are just some examples of how that works. So with that being said, this is my final slide. Moving forward, and then I'll open for questions, of course. Moving forward, if you have an offer, that is the time to start looking for attorneys. What I tell people is that as soon as you've been contacted, maybe as soon as you've gotten that appraisal letter, that would be the time to start looking for attorneys. Not necessarily hiring them, but starting to vet attorneys, starting to evaluate who you want to work with, and then when the offer's issued, that's when you hire the attorney. Once they issue the offer, you have a case. You're able to be hired as a client. Something we can look at, evaluate, and give you our thoughts. The time to hire an attorney is when you get the offer. Now, someone might be curious. Well, what if I don't hire you now, but I hire you at court? So you let it go all the way to eminent domain and then hire me. Well, first of all, there's no guarantee that I'll be able to help you. There's no guarantee that I'll take the case on at that point, just like there's no guarantee that I would take the case on now, but at least you would know. And that would be probably a bad course of action. To wait until eminent domain to make a decision like that, it's a risky play. I'll say that. You're risking quite a bit to get all the way to the court. That might necessitate costs for appraisals that you maybe didn't need to incur. That's not to say that if you have a case that I won't, still help you at that point, but it would be better to know that, I think, sooner rather than waiting for it to get to court. Let's see. And then, again, don't be rushed into a decision. If you have a group of landowners that are all near each other and you guys are working together on this, it's something that happens infrequently, but it does happen. If you come to me and say, well, we're all together, what can you do? I might be able to work with you on a discount on our fees in that instance. That's our phone number. That's my phone number, I should say. You can text that number, 470-869-1383. That is my email address, jordan@landownerattorneys.com. Feel free to email, text. I don't charge for this type of assistance. You're not going to get a bill from this webinar. You're not going to get a bill from a case review. I can't tell you the last time I actually sent a bill to a client. It happens very infrequently, maybe once every couple of years. So don't be worried about that. You're getting invoiced from our firm for this type of advice. We're happy to provide it. In this forum, and I'll end on this. Again, there's only one chance in these scenarios. There's no takebacks. I've had folks contact me after they've signed the paperwork. I had a guy contact me last week saying, "Hey, I signed an easement a month ago, but I'm not sure about it. Can you look at it?" And my response is, I can look at it, but there's nothing. Once the ink is dry, once the deal is done, the documents have been recorded, there's no going back. So it's imperative that you make sure everything is proper and done, how it should before you sign the paperwork. So I'll end on that. And with that being said, I will open for questions if anyone has any. Okay. I'm not seeing any questions. Give it a little bit more. Okay, well, guys are easy. That not a big deal. If you have questions and you didn't think of them, not just shoot me an email, shoot me a text. If you're interested in looking at the acquisition on your parcel from the public records we've collected that allowed us to mail to you, I'm happy to provide any maps that we have. Oh, I'm sorry. It looks like chat is disabled for some reason. So if you have QA, I don't know why that's. I'm not sure why it says that. If you have a question, use the Q&A. We're not doing. There's other question. We're not doing talking for the attendees, so the questions should be written. The Q&A function should work. It doesn't look like the chat's working for some reason. I'm not sure why. I'm trying to let's see. There we go. Okay, the chat should work now if you want to use it. You can also use the Q&A function as well, but if the chat isn't working, please let me know still. Okay, there's a question. Go over your fee again. Great question. And then I'll get to that next question. Go over your fee again. Our fee is I'll pull up the slide again so you can see it. Let's see. So my fee, this is how the fee works. A very easy example is if you have a $10,000 offer and you hire our firm and we get you $100,000, our firm would be 33% of the value we add to the case. So that would, in this case, it'd be a third of the 90 that we add. One question we get a lot is, what if you get the same amount, or what if you get less? Well, first of all, we've never gotten less for a client. It's not a guarantee. It's just a statement of our historical abilities on clients' cases. And if we end up back where we started, then I don't get a fee. In any event, if it's less or the same amount, I don't get paid. So I only get paid if I get you more than what is offered. And our fee is a third, 33% of any amounts recovered as part of our recovery over and above the offer. Okay, another question. Okay, my question is, if a property is already considered eminent domain, does that mean the government has already decided what to do, what to take, and can't do so? Property isn't, I guess I'm struggling with the phrasing of that. If you are in eminent domain, which means you've had a lawsuit filed against you and you've been served with that lawsuit, that means yes, the government has decided what they want and what they want to acquire. Eminent domain basically just is the course by which the government goes to the court and says, hey, we want to take this land. Will you let us take it? And the court generally says, yes, you may take that land for the road project, and it happens in the litigation. So that, I guess, hopefully that answers that question. But I will say that if your case is an eminent domain, meaning you have been sued, they have initiated the litigation against you, yes, that means that the DOT, the government, knows exactly what they want and what they want to take. They don't get to take it unilaterally. They need the court to give them permission. No, it's fine. That's when I said may be subject to, the follow-up question was, a letter I received says may be subject to eminent domain acquisition. I just didn't understand that. What that means is the letter, your property may be subject to an eminent domain acquisition, meaning what that long and short means is that your property is in the line of a road project. That means that GDOT has come up with a road project, no matter what, whatever it is, and your property exists in the path of that project. And what that tells me is that your property is needed and it's wanted in some shape or form. And for purposes of these acquisitions, I mean, because GDOT has this inherent ability to go to the court and get permission to take your property, we consider these negotiations, these acquisitions, made under the threat of eminent domain at the very least, because with road projects need to happen and they can't be stopped by individual landowners. So we basically, if you're on a path, you're not only on the path of that project, you're on the path of an eminent domain acquisition, which is why we term it like that and phrase it like that. I apologize for the confusion. I hope I answered that. Okay, there's another question. What is ROW? It's a great question. ROW stands for right of way. Right of way is the term basically that refers to property. And right of way is effectively what it means, is what it stands for. And it's a term that is used kind of interchangeably in these acquisitions. It's generally thought of as the land needed for the road project. So, as an example, when they come to you and issue an offer, they'll say, we want an acre of ROW. And that's basically an acre of land, an acre of right of way that the right of way is being given to the Georgia Department of Transportation. But it is, when I say right ROW agent, I'm talking about a right-of-way agent, a land acquisition agent. It's effectively interchangeable with the word property. So property agent, right-of-way is property. It's the same thing. It's just a term. Okay. Other questions? Another question, does our firm help with deed updates? I will say that we are an incredibly niche firm, and that's on purpose. We want to focus our attention on only eminent domain acquisitions. There's a lot of law involved with property generally, of course, and there's a lot of property lawyers that don't do eminent domain. There's a lot of eminent domain attorneys that don't do property things. We generally don't do just general conveyances, title work, quiet title. It's not something that we do. And also it would be very expensive for you to hire us to do something like that because we bill a pretty high rate. So that's for folks that we bill. We don't bill to our eminent domain clients. We do contingency. Absolutely. And another question, do we have an office in Atlanta? Yes, we do. Our offices in Alpharetta. That is our Atlanta office. We also have offices in Indianapolis, Springfield, Illinois. We have one in Ohio, North Carolina. But yes, Alpharetta, Northside office in Atlanta. I am the only Georgia attorney in our firm. I'm the only licensed Georgia attorney. If you were to work with our firm, you'd be working with me. So yes, we do have an Atlanta office. Other questions? Okay. I'm not seeing any further questions. So, okay. Well, with that being said, I'll go ahead and wrap this up, folks. Thank you so much for your time. Thank you for the questions. I appreciate that. Again, if you have questions, if you have further questions, you want to talk personally, if you have an offer that you'd like for me to review for free, let me know. Shoot me an email, shoot me a text. You're welcome. Everyone is welcome for my services today. Yeah, again, if you have an offer, send it to me. I'm happy to look at it for free, give you my thoughts. If you're curious about maps, what the acquisition looks like as planned by GDOT or by the municipality, shoot me a text, shoot me an email. I will get that out to you as soon as possible. And yeah, thank you so much for attending this afternoon, and good luck.